Hi there. I'm Ryan Harris, partner with Envoy Global. I'm here to discuss recent news from the U.S. Department of State, which is expanding the vetting requirements for individuals applying for H-1B visas and their H-4 dependents. On December 3rd, 2025, the Department of State issued guidance expanding the vetting requirements for individuals applying for the H-1B specialty occupation visas and their H-4 dependents. The measures include additional document verification, heightened scrutiny of employment arrangements, more detailed background checks, and most recently, online presence reviews, including social media accounts. The guidance expands online presence reviews to H-1B applicants, their H-4 dependents, and F, M, and J category non-immigrant visa applications. As part of this process, consular officers will require that applicants make their social media accounts public by adjusting privacy settings. While consulates often continue processing visas, regardless of privacy settings, employers and foreign nationals should be aware of this development and watch for emerging trends such as 221G notices tied to social media reviews. Applicants can consult with their legal teams for more details if they receive such requests. It remains unclear for now what precise online content could be cause for a visa denial, but the administration has made vague references in terms of monitoring for what could be perceived as anti-American, anti-Semitic views, as well as specific reactions to recent news events such as the killing of activist Charlie Kirk or the shooting of National Guardsmen that recently took place in Washington, D.C. Travelers should consider this in determining what they post online or in their online reactions to the post of others that could fall into an area of concern. The State Department has extraordinary discretion when it comes to issuing or denying visas, and decisions at the consulate may not be subject to further legal challenge. Just this week, U.S. consulates began canceling and rescheduling H-1B and H-4 visa appointments as they expand the online presence reviews, with many rescheduled dates being delayed by months into 2026. For instance, we've seen December appointments rescheduled into the range of March to July of 2026. Reports indicate that new vetting procedures are disrupting scheduling and extending wait times, and consulates are advising that arriving on a previously announced appointment date will result in your being denied admission to the embassy or consulate. The U.S. Department of State has not yet issued an official statement on appointment cancellations. To be clear, we anticipate that any visa appointment scheduled on or after December 15th, 2025 is for now at risk of cancellation and rescheduling with months of delay. Travelers should thus expect significant delays when applying for an H-1B or H-4 visa stamp due to appointment cancellations and could see what are known as administrative processing delays while the online presence review procedures are newly implemented worldwide. Administrative processing, shorthand for additional security clearance screenings, can last weeks or even months and typically cannot be expedited for any reason. The risk of travel delays are compounded by prior State Department policy shifts recently, including the total elimination of Dropbox or renew by mail procedures and new requirements that visa applicants may only apply for a visa in their country of citizenship or residence. If you have upcoming international travel and require visa stamping before you return to the U.S., for H-1B and H-4 particularly, you may want to reconsider your travel plans as your stay abroad could become much more prolonged than you had anticipated. If you are traveling with a valid visa and intended to apply for a visa renewal on an upcoming trip, we recommend that you consider foregoing the visa renewal appointment and instead returning before your existing H-1B or H-4 visa stamp expires. If you decide to travel and apply for a visa, be sure to make contingency plans and understand your ability to work remotely from outside the U.S. by discussing your plans with your leadership at work. Travelers should expect that obtaining expedited visa appointments due to an earlier appointment cancellation may not be possible, given the widespread effects of this policy, but should consult with an attorney if you have compelling grounds for an earlier appointment. On reentry to the U.S., it is important that you present both your valid visa stamp and your H-1B or H-4 approval notice, called Form I-797, to the admitting CBP officer. In other words, don't just present the visa, present it along with your approval notice. We also recommend you review your I-94 entry record, which can be obtained online, with your counsel each time you re-enter the U.S. to ensure you are admitted in the correct status and that you understand when that period of admission expires so you can always avoid an overstay. Thank you all for watching. Be sure to head to envoyglobal.com to keep abreast of any further news alerts on these and other topics.